Let's bring in our expert panel. Former Fulton County Public Defender Chandelle Summer. Also with us, former President Trump's impeachment attorney David Schoen. Also, let's bring in our special guest for today in studio, former New York Lieutenant Governor Betsy McCoy. She's also a New York Post columnist. David, I'll start off with you first. We won't see the spectacle of Trump going to and from court for an arraignment now in this case, but Fulton County has just said that they will broadcast a trial on a YouTube channel. So cameras will be there. I think we're going to see more attention to this case than we saw even for OJ. Will this help or hurt the case?
It's an interesting question, but I would really hope that the case is going to be removed to federal court. It fits every criteria for that. There's a case from Georgia, federal court in Georgia, called Georgia versus Hines. Right on it. He clearly was acting in his official capacity under color of law. He wouldn't have had the phone call with the Secretary of State if he weren't. He was operating under the Constitution's take care that the laws are faithfully executed clause. This case ought to be removed to federal court, which will remove the idea of television cameras. On the other hand, if it goes in state court, I think there's a great public interest in the case. So I like the idea that it's televised, but I'm afraid of the lawyers' egos tend to take over when it's televised and becomes a circus.
Excellent points there. Also, Chandelle, former Trump Chief of Staff Mark Meadows, as you just heard David mention, too, they're also petitioning to move their cases to federal court. The judge has promised a ruling on Meadows' request any day now and has set a September 20th hearing date for the other defendants. If they are successful, how do you think that would impact the case against Trump?
Well, that's going to make a big difference because I think that's going to give Trump the go-ahead to file a removal petition. The only problem is he has to file it by September 14th. So if the judge is indicating that the other two defendants' removal petitions are going to be heard on September 20th, he may not be planning to issue a ruling until all of the removal petitions are there. Certainly, there's some arguments in favor of removing the case to federal court. You get a broader jury selection from broader counties, which include counties that are very Trump-oriented. However, state court versus federal court, state court is a little looser in terms of how you can try the case. In federal court, they let the judge basically read your jury questions. In other words, they let the judge read the questions to the jury.
Right.
It cuts down on jury selection, whereas in state court, it's wide open. For example, right now in Fulton County State Court, they have a RICO case going on. They've been picking a jury since January. So that's 10 months they've been at jury selection. If the same thing were to happen in the Trump case, it could be years before they get a jury because everybody seems to have an opinion or have expressed an opinion about Donald Trump. That's going to be hard to sort through.
Absolutely. And the fact that it took them 2.5 years to indict him when he's such a so-called threat to democracy, just when he's surging in the polls, and now they want a speedy trial. Now, Betsy McCoy, there's even talk about removing Trump from ballots so that people can't vote for him. Tell me this is not true. This is an assault on democracy now.
Yes, it is. This is the ultimate in election interference trickery. Left-wing groups have written to the secretaries of state in many swing states and democratically controlled states, telling the secretaries that they should eliminate Donald Trump from the ballot.
Wow.
Claiming that he is ineligible to serve in any public office, including the presidency, because he's, quote, an insurrectionist. Now, mind you, this is guilt until proven innocent, just the opposite of what our system of government believes in. They're saying it doesn't matter that he's never been convicted of insurrection. In fact, none of these prosecutors even charge him with insurrection. There's an arcane section in the 14th Amendment written just after the Civil War, and it was really intended to eliminate Confederate generals and Confederate office holders from coming back into the government. But now they're using it after all this time to try to make Donald Trump ineligible for office. As I said, it's real trickery.
Absolutely. David, before I let you go, we have about a minute left as President Trump's impeachment attorney. What is your prediction on all these cases? Because they seem to be crumbling at this point.
Yeah, just a couple of quick points. Number one, if Meadows' petition for removal is granted, the whole case goes up. They can at some point try to remand some of the other defendants. But Trump should have filed his motions earlier. He should have been the first one to file. But if Meadows wins, the whole case goes up to district court, federal district court. On this 14th Amendment question, I think it's outrageous. I don't think it will prevail. It ignores his exoneration in the impeachment trial that was specifically about insurrection or seditious conspiracy, that sort of thing. The prosecutor had every opportunity to charge seditious conspiracy or sedition or insurrection here. This federal code section 2383, they chose not to charge it. Constitution's clear in Article 2, Section 1 on the qualifications for president. President 14 years, over 35 years of age, American born. Those are the qualifications. We can't modify that now. I think it's an outrageous effort. I think it harkens back to Jerry Nadler a couple of years ago saying we can't trust the American voters. We must trust the American voters. That's our democracy.
Absolutely, the democratic way. Thank you so much. Brilliant analysis from all of you. David Schoen, Chandelle Summer, and then Betsy McCoy. We'll talk to you again real soon.